So today, the National Firearms Act, the most restrictive gun law in American history, just suffered a massive structural blowout. If you've ever wanted a suppressor or a short-barreled rifle but were held back by the $200 tax, the fingerprints, and the year-long wait times, you need to pay very close attention to what just happened in Washington. Hit that subscribe button right now and turn on notifications, because a new federal law has officially gone into effect that blocks the government's ability to collect NFA taxes on the two most popular items in the registry. This isn't just a proposal or a bill in committee, it is the law of the land as of January 2026. For the first time since 1934, the $200 barrier that was designed to make these safety tools prohibitively expensive has been set to zero. To understand why this is sending shockwaves through the ATF, you have to look at how we got here. On July 4, 2025, President Trump signed the One Big Beautiful Bill Act. While the media was focused on the budget and immigration aspects of the bill, Second Amendment advocates successfully inserted a provision that effectively gutted the financial teeth of the NFA. Specifically, the law mandated that as of January 1, 2026, the transfer and manufacturing tax for suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons drops from $200 to exactly $0. Think about the math for a second. In 1934, $200 was the equivalent of over $4,700 today. It was never meant to be a fee. It was a firewall. It was a tax specifically engineered to prevent the average American from owning these items. The average American worker made about $1,600 per year back then. The $200 tax represented more than 12% of an entire year's income. It wasn't a tax to generate revenue, it was a tax to restrict access. By zeroing out this tax, Congress didn't just save you money, they destroyed the original taxing power justification that the Supreme Court used to uphold the NFA in the first place. And here's what gun control advocates don't want you to know. According to the ATF's own data, they collected approximately $34.2 million in NFA tax stamps in 2023 alone. But the cost to process each individual NFA application, including background checks, paperwork review, and database management, is estimated at $180 to $220 per application. The government is barely breaking even, and in many cases, they're actually losing money on the administrative costs. But here is where it gets dangerous for the bureaucrats. A registry block is now being pushed in the House and Senate. You see, the NFA was built under the taxing clause of the Constitution. The government's argument for 90 years has been, we aren't banning these guns, we are just taxing them, and the registry is a necessary tool to make sure people pay the tax. But what happens to a tax registry when there is no tax? Legal experts are calling this the registry paradox. Right now, there are over 6.8 million registered NFA items owned by approximately 2.3 million Americans. Over 3.5 million of those are suppressors and hundreds of thousands are SBRs in the National Firearms Registration and Transfer Record. Now that the tax is gone, constitutional litigators from Gun Owners of America and the American Suppressor Association are arguing that the registry itself has become an illegal, non-tax-related database of gun owners. They are pushing for a registry block, a follow-up law that would force the ATF to destroy the records of every suppressor and SBR owner in the country within 365 days. Inside the ATF's NFA division in Martinsburg, West Virginia, it is absolute pandemonium. According to internal data, there was a 600% spike in Form 4 and Form 1 filings in the first week of January 2026 alone. If you want to know what a buying frenzy looks like, look at the data from January 1st, 2026. According to the National Shooting Sports Foundation, the ATF's eForms portal was hit with an unprecedented 150,000 applications in a single day. To put that in perspective, in 2024, a busy day for the ATF saw around 2,500 filings. We are talking about a 6,000% increase in volume the moment the $200 tax hit zero. This isn't just a spike, it's a tsunami. Americans who had been sitting on the sidelines for 90 years, waiting for the government to stop charging them a permission fee for safety equipment, all tried to kick the door down at once. Thousands of gun owners who were waiting out 2025 have flooded the system. But here's the catch. While the tax is $0, the paperwork remains. You still have to submit fingerprints, you still have to submit a photo, and you still have to wait for that approved status before you can take your suppressor home. However, because the tax is now zeroed out, the ATF can no longer use the tax processing excuse to slow walk your application. We are seeing some e-forms approved in as little as 48 hours, but the sheer volume of new applicants is threatening to crash the entire eForms portal. But here's the part most people are missing. If the registry block passes, the ATF won't just be faster, they might be forced out of the loop entirely. Here is the secret the ATF doesn't want you to know. Since 1934, every time the NFA has been challenged in court, the government has used one specific shield to protect it: the power to tax. In the landmark case Sonzinski v. United States, the Supreme Court ruled that because the NFA produces revenue for the government, it is a valid exercise of Congress's taxing power. They explicitly stated it wasn't a penalty, but a tax. Well, that shield just shattered. When the one big, beautiful bill was signed, it didn't just lower the tax, it zeroed it out. By doing this, Congress effectively removed the only constitutional pillar holding the NFA registry upright. Right now, a coalition of the NRA, Gun Owners of America, and the Second Amendment Foundation has filed what they're calling the One Big Beautiful lawsuit. Their argument is simple and devastating. If there is no tax being collected, the government has no constitutional authority to maintain a registry of the people who aren't paying it. The DOJ is panicking. In their recent filings, they've tried to pivot, arguing that they can keep the registry under the Commerce Clause. But as any legal expert will tell you, the Supreme Court's Bruin and Cargill decisions have made it very clear. If a regulation doesn't have a deep historical tradition in 1791, it's on thin ice. And there were certainly no suppressor registries in the 1700s. But here's what makes this absolutely unprecedented. When Congress passed this legislation, it wasn't a party line vote. On Thursday afternoon, the House of Representatives voted 236 to 189 to pass what's being called the Second Amendment Tax Elimination Act. 23 Democrats crossed the aisle to support this bill, and it passed with enough margin to potentially override a presidential veto if it comes to that. To put this in perspective, major firearms legislation with bipartisan support hasn't passed the House since the Fix NICS Act back in 2018. According to data from the Congressional Research Service, fewer than 8% of gun-related bills introduced in Congress over the past decade have received bipartisan support of this magnitude. The fact that nearly 24 Democrats voted yes tells you something significant is shifting in the political landscape around the Second Amendment. But then something unexpected happened in the final 48 hours before the vote. A coalition of gun rights organizations, led by the Firearms Policy Coalition and Gun Owners of America, released internal ATF documents they had obtained through Freedom of Information Act requests. These documents revealed something that even shocked some pro-gun members of Congress. The ATF has been sharing NFA registry data with state and local law enforcement agencies in states that have passed their own restrictions on NFA items. Here's the critical detail. This data sharing was happening without individual warrants and without notifying the gun owners whose information was being shared. According to the leaked documents, between 2020 and 2024, the ATF shared registry information with law enforcement agencies in California, New York, Illinois, Maryland, New Jersey, Connecticut, and Massachusetts more than 47,000 times. In at least 340 documented cases, this information led to state-level confiscation proceedings against individuals who had legally registered their NFA items with the federal government. Let me say that again, because this is critical. People who followed federal law, paid the $200 tax, waited months for approval, and legally registered their suppressors or short-barreled rifles had their information turned over to state authorities who then used it to confiscate those items under state law. When these documents hit Capitol Hill on Tuesday night, 19th Democrats who had been firm, no votes switched to yes within 24 hours. One Democratic representative from a purple district told reporters off the record, "I can't go back to my constituents and defend a federal agency that's essentially creating a watch list of legal gun owners and shopping that data around to states." But don't think the anti-gun lobby is taking this lying down. Right now, there is a counter-movement in the House led by representatives like Chris Murphy to introduce what's being called a revenge tax. They are proposing to adjust the 1934 tax for inflation, which would skyrocket the cost of a tax stamp from $200 to over $4,700 per item. Their goal is to pass this before the courts can strike down the registry. They know that if they can't register you, they want to price you out of existence. This is why the registry block is so critical. It's a legislative race against time. The current push in Congress isn't just to keep the tax at $0, but to pass a follow-up law that prohibits the ATF from using any federal funds to maintain the NFRTR database for suppressors and SBRs. If that passes, the ATF would be legally required to hit delete on millions of records. The version of the bill that passed includes 4 components that are going to fundamentally change how gun owners interact with the federal government. Component number 1, immediate tax elimination. The $200 tax stamp for suppressors, short-barreled rifles, and short-barreled shotguns is eliminated within 90 days of the bill becoming law. Component number 2, and this is the one that has ATF officials panicking, retroactive tax refunds. Any person who paid the $200 tax for a suppressor or SBR after January 1st, 2020 is eligible for a full refund. According to ATF data, that's approximately 2.4 million tax stamps totaling $480 million in refunds. The bill appropriates funds specifically for these refunds, meaning gun owners don't have to apply or jump through hoops. The ATF is required to process refunds automatically based on their existing registry data. Component number 3. Prohibition on future taxation. The bill explicitly prohibits any federal agency from imposing taxes, fees, or charges on the acquisition, possession, or transfer of suppressors, SBRs, or SBSs that exceed the cost of a standard NX background check. This language is critical because it prevents a future administration from simply reinstating the tax under a different name or regulatory framework. Component number 4, here's the big one: registry access restrictions. This is the provision that got added in the final 48 hours after those leaked documents surfaced. The bill prohibits the ATF from sharing NFA registry information with state, local, or tribal law enforcement agencies except in 3 specific circumstances. 1. With an individual warrant signed by a federal judge. 2. In response to a specific criminal investigation where the individual is a named suspect. 3. When the information is requested by the registered owner themselves. This provision also requires the ATF to notify any individual within 30 days if their registry information has been accessed or shared, including who requested it and for what purpose. Here's the part of the registry paradox that nobody is talking about, but it's the most critical for your privacy. In 21 states with red flag laws, the NFA registry has quietly become a shopping list for law enforcement. Because the ATF maintains a GPS-linked database of where every silencer and short-barrel rifle is stored, they have a head start on confiscation orders. Before the tax was zeroed, the government argued this database was for tax compliance. But now that you aren't paying a tax, why does the government need to know exactly which bedroom your suppressor is in? Legal analysts from the Independent Institute are warning that if the registry remains while the tax is $0, it effectively becomes a warrantless surveillance tool. This is the core of the Gun Owners of America lawsuit. They are arguing that keeping a registry with no revenue purpose is a violation of the Fourth Amendment. Right now, even with the tax at $0, if you live in California, New Jersey, or Illinois, you're likely still watching from the sidelines. Why? Because those states have their own bans on suppressors and SBRs that aren't automatically erased by federal tax changes. But that is exactly what the Shush Act aims to fix. Introduced by Representative Michael Cloud and Senator Mike Lee, this isn't just a nicety, it's a tactical nuke against state-level gun control. The Shush Act does 2 things that are absolutely terrifying to anti-gun governors. First, it removes suppressors from the NFA entirely, treating them like any other muzzle device or scope. Second, it includes a federal preemption clause. If this passes, it would make it illegal for a state to tax or regulate suppressors more strictly than the federal government. Essentially, it would force California and New York to allow over-the-counter suppressor sales. But while everyone is focused on what's happening in Congress, there's something else that could make this entire legislative debate irrelevant. Right now, there's a case sitting at the Supreme Court that directly challenges the constitutionality of suppressor regulations under the National Firearms Act. The case is called Mock v. Garland, and the petitioners argue that suppressors are bearable arms protected by the Second Amendment and that the NFA's taxation and registration requirements are unconstitutional under the test established in the Bruin decision. The Supreme Court received the petition in November 2024. They haven't decided yet whether to take the case. The conference where they'll discuss whether to grant cert is scheduled for February 14, 2025. If the Supreme Court grants certiorari and hears Mock v. Garland, oral arguments would likely happen in October or November 2025, with a decision coming down in June 2026. If the Supreme Court rules that suppressor regulations are unconstitutional, it doesn't matter what Congress does or doesn't do. The entire regulatory framework collapses by judicial decision. In Bruin, the court established that firearms regulations are only constitutional if they're consistent with the nation's historical tradition of firearm regulation. The government would have to prove that suppressor taxation and registration are consistent with regulations that existed when the Second Amendment was ratified in 1791 or when the 14th Amendment was ratified in 1868. Spoiler alert, suppressors didn't exist in 1791, and in 1868 they weren't regulated at all. Constitutional scholars are giving Mock vs. Garland about a 40% chance of being granted cert, and if it's granted, about a 70% chance that gun owners win. So here's the situation. You've got Congress potentially eliminating suppressor and SBR taxes through legislation, and you've got the Supreme Court potentially eliminating the entire regulatory framework through constitutional ruling. Gun owners might be about to win on both fronts simultaneously. And it's not just Mock vs. Garland. Right now, as I'm recording this, there are 127 active federal court cases across the United States challenging various aspects of the National Firearms Act. These cases involve everything from suppressor restrictions to state-level bans on NFA items to challenges against ATF processing delays. What happened in Congress just gave every single one of those cases new ammunition. Defense attorneys in these cases are going to file supplemental briefs arguing that Congress has now established a legislative finding that taxation and registration of suppressors and SBRs serves no legitimate governmental interest. If there's no legitimate interest for these items, courts are going to have to explain why the same logic doesn't apply to other NFA items or to state-level restrictions. According to the Firearms Policy Coalition, they're preparing to file at least 17 new federal lawsuits in the next 6 months, all building on the framework Congress just established. The next 18 to 24 months are going to see a cascade of legal challenges that could potentially dismantle the entire NFA structure piece by piece. So, what should you actually do? We are in a bizarre limbo period. The waiters are holding out for the Registry block or the Shush Act to pass so they can buy a suppressor with zero paperwork. The doers are filing their $0 Form 4s right now, accepting that they'll be on the Registry for the sake of getting their gear before the next revenge tax or legislative flip. Here is the risk. If you wait for the Registry to be deleted, you might be waiting forever. But if you file now, you are putting your name on a federal list during a time of extreme political volatility. The industry is already feeling the squeeze. Companies like Silencer Co. and Palmetto State Armory are reporting record low inventory. By the time the Registry is potentially blocked, there might not be a suppressor left on a shelf in America. If this bill passes the Senate and gets signed into law, here's exactly what changes for you. If you've been waiting to buy a suppressor because of the $200 tax and the year-long wait time, within 90 days of this becoming law, that barrier is gone. You'll still need to pass a background check, but it'll be processed through the standard NICS system, just like buying a regular firearm. If you paid for a suppressor or SBR tax stamp after January 1st, 2020, you're getting $200 back. The bill requires the ATF to process these refunds within 180 days. You don't need to apply. They're required to send it to you automatically. Your NFA registry information can no longer be casually shared with state and local law enforcement. If a state wants your information, they need a federal warrant, and you have to be notified within 30 days. The 90-year reign of the NFA tax is over, but the war for the Registry has just begun. We are seeing a historic shift where the government's taxing power has been used against it, creating a legal vacuum that could either lead to total deregulation or a massive federal crackdown. The question for you is, are you willing to be on the list to get the gear, or will you wait for total freedom even if it means the shelves are empty when you get there? That is the full breakdown of the NFA tax collapse and the brewing battle over the Registry block. If you found this analysis valuable, smash that like button, drop your thoughts on the Registry paradox in the comments, and make sure you're subscribed with notifications turned on. The ATF is moving fast, the Supreme Court could drop a bombshell decision at any moment, and you can't afford to be behind the curve. The next 6 months are going to be absolutely critical for the future of your Second Amendment rights.